De verdad que son los mejores, me encantaría que fuera. Sí, vámonos a Chile. En Chile, yo tengo un terreno que cuando lo compré ese terreno, se va a hacer un científico en Chile. Ahí está, 22 hectáreas. Así que, pues también estamos esperando. Actually, at the new land, by the way, it should 3 hectares there and a place. Waiting for you. De hecho, she already made. No tengo otra vez.
Check, 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 check.
Pero nosotros vamos a hacer un trabajo. Hoy día ya no hemos ganado la entrevista, de esto no te mostré, pero me llegó un video de alcalde reconociéndonos, agradeciéndonos que mira, me llegan a parar los pelos ya hace 3 años. Entonces, uno de los trabajos que nosotros partimos haciendo ahí fue rescatar primero los oficios ancestrales antes que murieran los abuelos. Después de eso, nos fuimos a trabajar el cambio climático y pueblos originarios, ¿ya? Te quiero mostrar el libro, no te lo voy a pasar porque realmente te lo puedo mandar a Chile, Chile. Este es el Papa. Es el Papa.
Check, check.
Julien? Florencia? Wait.
Okay, so are we all sitting up there?
So for now, yes, because we're missing one speaker, so everyone can be on.
Okay.
Unless you prefer me to call your name for block 3. Okay, so yes, you can. Hi.
Hi, how are you?
I am doing fine. We were waiting for you to come join us.
Just now?
Yes. Is it okay or?
No problem, no problem. Picture.
Ah?
Picture.
They got.
No problem.
I think they never received the picture, so they took one online. I will tell them that it's not the right one. We waited for the biography. We never
No
received.
problem.
Yeah, I understand. Yes.
No problem. Please, I'd like to know if you will be the moderator. I don't know if you have the specific question.
Yes, I do. I send it to you and to.
If you have, because if you can raise some question about international law in the University of Morocco, I can judge it and the importance and the role of international law in the field of climate action.
Yeah.
So question, okay?
Yeah.
Hi, I'm Ulises.
Oh, hi, how are you, sir?
Yeah, so
We will take another chair and I will be. Yeah.
Okay, so I think that we will start this panel. First of all, of course, I'm absolutely thrilled to be welcoming this important topic on the Climate for Science Action Pavilion that is co-organized with IPCC, WMO, and MERI Foundation from the Corte Solari Philanthropy. So we will be exploring today how international law can actually strengthen climate action through advisory opinions and litigation. We will then therefore examine the role of courts and legal frameworks in clarifying obligations, enforcing accountability, and shaping global norms under the Paris Agreement. Featuring leaders in science, policy, and law, this panel will highlight how legal interpretations grounded in scientific evidence are redefining responsibility and enhancing the legitimacy and effectiveness of global climate governance. In order to do so, we have decided to divide this panel in 3 main blocks, and each speaker will actually talk on one of these 3 blocks. After that, we will be open for questions if we have time. Unfortunately, we are running a little bit late. As you know, there was some issues this morning in order to enter the premises, so we'll do our best in order to keep the schedule ongoing. The first block will actually will be dedicated to setting the scene to the topic and to explain how international law can advance global climate action by defining obligations, shaping norms, and reinforcing commitments under the Paris Agreement. We'll be talking about this topic, the professor on international law from Université Côte d'Azur, Julien Delot. Then we will have Florencia Ortuzar, who is the director of the Asociación Interamericana para la Defensa del Ambiente, And finally, last but not least, we have Ulysses España, who's the Director of Política y Legislación Ambiental. The second objective will be how states are translating international legal principles into concrete policies and actions and actually assess the effectiveness of current implementation efforts. We'll be speaking about this. Alex Godoy, who is a member of the Scientific Committee of Climate Change of Chile, so depending on the Ministry of Science, Technology, Knowledge, and Innovation, and who's also an academic from a Chilean university called the University para el Desarrollo. We will then have Professor Futu Mohammed from the University Mohammed V of Rabat, who will be also talking about that topic. And finally, last but not least, to explore pathways for greater collaboration among states, civil society, and legal experts to strengthen accountability and drive systemic long-term change in global governance, we have the pleasure of welcoming Marie-Cécile Trevet, who has a double hat, I would say, which is why she will have the important role of during this symbiosis. She's president of Science Europe and also the head of the Research Council for Norway. So thank you very much. With no further ado, Julien, do you want us to do the honor and set the scene for this important topic, please?
Hello? Yeah, okay. I will try to talk with the music behind. As Sarah said, I will try to set the scene and talking about the ICG advisory opinion and its contribution on climate protection. First, if we talk about this advisory opinion, we have to understand, I don't know if there is yeah. Perfect. The next one, please. Yeah, if we have to recall the context of this advisory opinion because we can see a convergence of procedure because there were 3 different advisory procedure that has been initiated during the 3 last years and 3 advisory opinion that has been given by the International Tribunal for Law of the Sea, Inter-American Court on Human Rights, and of course the ICG on July. So we have a convergence, but as well in the same time a divergence because of the different jurisdiction. Indeed, ITLOS and Inter-American Court on Human Rights have a limited jurisdiction, either materially for the International Tribunal for Law of the Sea because it interprets the Montego Bay Convention, and as well personally, especially for the Inter-American Courts that give advisory opinion to the member of the Organization of American States. On the contrary, the ICG have a general jurisdiction on the material and the scope because it can settle and answer to any legal question. So the ICG advisory opinion have a particular importance, but we know it's advisory opinion, so it's only a moral authority, but it's not binding by itself. But it was adopted unanimously and have even greater authority. And it is used by the ICG and other tribunals to settle dispute in the future. So we're going to question the contribution of this advisory opinion in 4 ways. The ICG had to answer 2 questions that will be our 2 first, like what are the obligations of states to protect climate and what are the consequences of potential breach. After that, we will discuss a specific question that I think will interest the roundtable, how the ICG brings science in its advisory opinion and what influence can it have. And at the end, what is the influence of the advisory opinion on further cooperation? So first, the question that bring naturally, it's please, the other one, yeah, thank you. How the ICG clarified the legal obligation. I will go quickly because I could speak for 2 hours about it, but we can see that the ICG distinguish and affirm 2 kinds of norms, of course, on a treaty basis or on a customary basis. On a treaty basis, we can see that the ICG made an ambitious interpretation because, for example, if we look at the objective of the convention and more especially to the Paris Agreement. We know that the Paris Agreements have a two objective, like 2-degree maximum increase and to pursue effort to limit to 1.5. But the court didn't stay in this two objective and said the real objective now it's 1.5. So it bring increase in ambition, and it's based on the COP decision that was been adopted at the end of the global stocktake. So the ICG increased the level of ambition, as well said that there is binding obligation in the convention and the Paris Agreement, this based on the tense used. And even if these obligations are results of mean, it doesn't have any importance. And as well, even if they are imprecise, they remain binding. So it gives a really ambitious interpretation to increase the level of obligation and ambition. So we have procedural obligation to communicate NDC. This was more or less what we could think when we look at the Paris Agreement. But the court as well said that the content of an NDC is not at the fully discretion of state, and it's really constrained by the Paris Agreement. And the court said that it exists as well a substantial obligation to implement with due diligence NDC. So it's really a great interpretation that go further than the basic consensus that is settled in the Paris Agreement. The courts say as well that we have customary obligations that are independent, and this is based on the previous decision, and it's only applied to the climate. But the court said that we have due diligence obligation to prevent damage coming from climate change. It's a little bit, I will not go into detail, but the court brings some confusion. But if we see with the previous decision and this advisory opinion, we have a substantial obligation to take measure to avoid damage. We have procedural obligation to elaborate impact assessments, and we have procedural obligation to inform and notify about the potential damage. And the court precised that in order to evaluate the implementation of this obligation, we have several factors that we have to take into account. The scientific knowledge, we will talk again about it, and the existence of international norms or consensus, and the differentiated capabilities of states. I will go with further. I will try to be quick. The court said a few things that are interesting to engage responsibility. Based on the advisory opinion, we know that we have an extended invocability because any state will be able to bring an engaged responsibility for climate protection or violation breach, because we have erga omnes and erga omnes partes obligation. And the court said as well that state will be responsible for the insufficient regulation of private actor. We could think that it was the case, but it's stated clearly. And for reparation, we already know based on previous decision that the court could repair environmental damage. And the court as well recalled that compensation will be possible, monetary compensation, even if the evaluation of the damage, it's hard. She can make an evaluation in general based on equity. The remaining and the main problem for future responsibility will be, of course, the facultative jurisdiction of the ICG. So I will be even more quickly with the last slide. I don't know if I still have a little bit of time. Okay, 2 minutes. So for the mobilization of science, which is interesting, I guess, we can see that in the advisory opinion, the courts affirm that the IPCC work is recognized as the best scientific information available, and it will influence the existence of norm on different levels based on the advisory opinion. We can see that influence the existence of the norm, as we know that the due diligence obligation need to demonstrate the existence of a risk. And she said that the IPCC work can be used to demonstrate the existence of the risk and then to create the obligation for state. It will as well influence the intensity of obligation, because the courts say that due diligence will be stricter as the scientific knowledge is greater. So if the scientific information is there, the due diligence and the conduct of states have to be even bigger, even stronger. And then the last side of this influence is the consequence on responsibility, because the IPCC work bring a sort of presumption of a causal link, a general causal link between human-induced activity and climate change and the damage. And finally, I will just say in 30 seconds, we can see that the advisory opinion can bring positive results for the negotiation, because it's crystallized the negotiation result, the obligation, and it affirmed the duty to cooperate, so the institution of the COP. But negatively, it could block, because it goes further than the consensus, it could block as well the next negotiation and the opposition between states. Hopefully, it will be only positive influence. Thank you. Sorry.
Thank you. Thank you. I think it provides a quite overarching context. Please.
Okay, thank you very much. It's a pleasure to be here. Thank you very much for your very interesting presentation. I'd like to begin by saying that these advisory opinions, that we've been saying this all along, but I think it's important to put it again and again, they don't invent anything new. They are based on something that is absolutely intrinsical to human nature, to human dignity, to the integrity of nature. So that's very important to have in mind. But the problem is that, as we all know, the eternal Achilles heel of international law is enforcement, because we don't have a global enforcing police out there. So it's up to us really to make them count, to come together with all sectors of society to become creative, to keep momentum going. So I want to thank these spaces, because that is precisely what we're doing here. So how will they operate in practice? That obviously has yet to be seen, but it will certainly vary from country to country and in the different forums. But we are already seeing some judgments and some plaintiffs coming on with arguments based on the advisory opinion. So it looks pretty promising, and I think it's more important than ever that we come together, that as people that use litigation as a tool or any other kind of advocacy come together, learn from our experience, the good and the bad, and we make the most out of them. So now, doing a little bit reflection on how these advisory opinions reflect international law as it has always been, I think it's safe to say, like, simplifying a lot, and thanks to your presentation, maybe it's not so bad that I simplify a lot. The three of them converge on that it's the state's duty to protect people and nature from climate harm. This means they have to prevent and reduce greenhouse gas emissions and other climate drivers, of course. They have to regulate and supervise private actors. That's an obligation as well. They have to cooperate internationally with other states to protect people and nature, and they must rely on best available science. And here the Inter-American advisory opinion goes even further to say that this science includes traditional and indigenous knowledge, which is beautiful. And they also underscore that all these obligations are erga omnes, so they are owed to the international community as a whole, and by all states, not the sitting government and not the state that signed this or that treaty. This is for everyone and has been there forever. So how does this connect with the classical international principles that are the basis of international human and environmental rights? I guess human rights and environmental law already told us, has been telling us for ages how climate policy should be developed and implemented. But I guess that we can sort of pinpoint some of these principles that are especially key into how states should deal with climate change to protect people and nature. So the most classical one, I guess, is common but differentiated responsibilities, because it means that all states have a duty, of course, but some have more responsibilities than others. And this is based on their capacity, but more so on their responsibility. So this is not charity, this is duty. Then there's the one of equality and non-discrimination, because it's a given fact that marginalized communities, the ones most vulnerable, are suffering the worst, and they are the less responsible. So this is the base for the duty that states have, developed states have, to provide support to undeveloped states, again, not as charity, but as a legal duty. And then there's participation, access to information, and justice. And this one, I think it's interesting to look at in the sense that it is not only a legal right of people, of communities to participate in what the decisions that are being taken that affect their territories. It is also a very valuable and important input that governments need to come up with the best solutions. So we need to start seeing it in that way, not only as a duty, but also as something that we need, that we cherish, to make the best out of the solutions that we can come up with. Then there's obviously intergenerational equity and the rights of future generations. I think that doesn't need any more explanations. And extraterritorial obligations and do no harm. I think that one is really like climate falls right there, because the ocean and the atmosphere has no boundaries. So countries have to take care of their emissions, even if they're doing it in their territories, because they affect the whole planet. So how do these advisory opinions contribute to clarify and strengthen global climate commitments? I guess we can sort of make a bit of a reflection there and say that, well, they consolidate, they don't invent or improvise, and that is very important to underline every time. Then they universalize the responsibility. That's what I was saying before about it doesn't matter if you signed the treaty or you didn't sign. They sharpened the standard of conduct. So now due diligence is stringent and it's science-based. And they link climate and human rights explicitly. They also mandate control over private actors. I think that's a very important one and a very good basis for more litigation that will help us move these advisory opinions. And they mandate that policies and plans follow strict science and even indigenous knowledge, as was said before. So how can we use them? It's up to us to use them, really, and up to all sectors of civil society, not only lawyers, but also communicators, artists are very important, academy. We must all come together. And I'd like to tell you about I don't know if many of you read the advisory opinion of the International Court of Justice, but I thought it had a very beautiful last remark. One of the last remarks, it says that these advisory opinions, they are much more than a duty for law. We need all sectors of civil society coming together, all human wisdom to make them count. So that's like a call for civil society, I guess. And we can do that by pushing domestic policy, demanded that they be honored in NDCs, in policy plans, etc., in courts and oversight bodies around the world, and obviously at COP30. We need to make decisions follow on the advisory opinions. So yes, I think that's it for now. Thank you very much.
Thank you very much. And to finalize this first block, I would like to give the floor to.
Thank you. Thank you for the invitation and in this relevant space. A little closer? Yeah. Okay, great. Sorry. So thank you for the invitation. Thank you for the space. I will try to get a little step before the litigation and advisory opinions, and how we as an organization have supported the development of legislation that takes into account participation and the need for information and the public society part in creating these laws that in turn will be able to view climate change and climate change solutions in a comprehensive manner. So the litigation and next steps are able to also allow us to understand the situations in each state. So I'm going to try to unite all these points. Let's see if I'm successful. But next one, please. Well, a little bit more, because I wanted to give the context. We already know we are in a planetary crisis. So the need for laws that tend to this crisis, it's key. So next one, because I guess we don't have much time. So let's start. Why are policies and laws relevant? And that's why I'm going this step before all of you. It's relevant because it establishes the goals any country, any states of national governments has to comply with, and it aligns with NDCs at the international level. So in this sense, it's key how we at the state levels of national level, we are able to establish goals that are adapted to the specificities of each country, the capacities, because for example, Mexico, the government doesn't have the same capacities as other countries. So we need to view this as a complex problem that needs complex solutions adapted to situations. And next one, please. So, well, this is a brief summary of what we do, but I would like to give way to the conversation in how we have been working with at least 19 of the 32 states of Mexico developing laws in what we call participative processes. Next one, please. And in these participative processes, we talk with academia, social, civil society, with the government, legislators, and so on. So we are able to understand the specific necessities of each state to create laws that are implementable. Because we always talk about having the perfect law. We try to address all the issues that are being discussed in COPs and so on. But we also need to understand these capacities hinder the possibilities to really create change. So in this sense, participation of all sectors, key stakeholders allows us to have laws that answer to these realities we are dealing with. Next one, please. And the interesting part, we have analyzed the results of these participative processes in documents like this one with University of Oxford. But I guess the best example of how the bottom-up approach can support developing laws is the exercises with these 19 states. Next one, please. Has allowed us to address some recommendations that come from the main principles and concepts that are already being discussed. For example, just energy transition is an issue that we all understand is key. But these participative processes have shown us that that's something that's been discussed at the bottom levels. And that's an example of how we all understand we are in this climate crisis and we need to work together to achieve results. For example, other part that, or at least for Mexico, it's key, is the incorporation of a climate justice perspective, because that's when we start talking about litigations and so on, because if we establish these principles in the law, then we are giving way for communities and others to take these principles and with litigation, defend the rights. So that's kind of, I'm trying to get to the part of litigation, how we are establishing this like baseline that allows us to protect the vulnerable groups and all the people with, or to take account into the implementation of several actions. And the next one, please. And finally, I would like to say that this work at the subnational level supported the ongoing development of the general law update of Mexico. We are in a moment, as many of your countries, that the new NDCs are going to be presented. And this bottom-up approach with establishing and harmonizing subnational legislation, it's probably, we expect next year, going to crystallize in a general law that includes these principles, these concepts, and then we are going to hopefully have a framework that allows for a much more ambitious implementations actions, but also allows to protect vulnerable groups and others. Next one, please. So now, which recommendations we are focusing on? For example, there's a net zero emission goal, but these emission goals can't be seen just as mitigations, because we have other issues in Mexico, like in many other similar countries, regarding loss and damage, for example. That's something that's going to hopefully have a specific chapter regarding loss and damage and how we are viewing not only adaptation, but that social part of adaptation. So then we start like, I guess I'm trying to unite all the points going towards how we protect people, because I'm not a lawyer, sorry, but litigation is about protecting people. You lawyers tell me. You lawyers tell me if that's it. But litigation is about how we protect people and how we protect vulnerable people. So these principles can support how we are going to protect them. Also, there are other concepts, market-based instruments and so on, but they need to have this social perspective that we try to promote through these participative processes. And next one, please. I think that's the final one. So as I was saying, this participatory process allows for laws to be adapted to reality. Because as I was saying, we can have the perfect laws. And sometimes in Mexico, we have like the best law, the more complex and so on. But if it's not implementable, if it's not rooted to how we work, how we function as humans, then it's irrelevant. So maybe that would be kind of my final remarks, and would thank you for the space.
Thank you very much. Thank you for this very enlightening example from Mexico. And now we're actually going to hear a little bit more about Morocco, if I understand correctly.
Thank you very much. Good morning or good afternoon. I would like first to thank the organizer of this important side event. And I would like ask you to excuse my English because I am speaking French speaking and Arabic speaking. But maybe the most important to transmit our communication. Maybe this topic of international law related to climate, it's very important, not as tool to explain some vague in the text or in some not a commitment, but some conference like Paris Agreement, but maybe it is a very useful tool to push social society, states to go to do court, to go to do legislation in order to ensure climate justice, but also to push states to respect their commitment in terms of NDC, in terms of mitigation, in terms of the adaptation measure. Maybe state can use this tool, but also civil society. It's very important but we have to reinforce the capacity of this civil society in order to use this tool at the international level. For example, in some country, like in my country, we use internal legislation for push government to respect some commitment like human rights related to environment and to clean water and to access to justice. But there is a need to reinforce the capacity of NGOs and also the negotiator in such or in some international bodies like COPs in order to insert this component in their negotiation, because it's very important to pass from the commitment to the implementation, because we have a gap between the commitment, but how we can reinforce this civil society, government, negotiator. Maybe this is the role of the university and also the role of the science community. We have to introduce and to reinforce this component at university level as topics of teaching and learning, but also is one component to ensure the cooperation between university and society and also private sector company. We know that this question of international law related to the climate, it's very important for companies responsible to the most problem related to the climate change. Maybe we need to reinforce this cooperation, but also the cooperation at regional, at international level, because sharing this information and the experience in the implementation and the use of this tool at regional, at international, it will be very useful tool to pass from the commitment to the action on the ground. Thank you very much.
Thank you. Thank you. Thank you very much for this very passionate intervention. I think we'll be hearing a lot more about the role of university and science later on, but turning now to our colleague from Chile in order to provide another perspective.
Hello, everyone. I know that I have 2 minutes, so I don't want to be very boring for you. So I am Alex Godoy. I am member of the second scientific committee on climate change. I am a faculty as well, but also I am member of the IPCC, like CLA, for the next assessment report 7. And I would like to talk maybe briefly on what we are doing in Chile. You know, the international position of the Chile always has been moving ahead with the climate goals. Indeed, we were leading the ILAC in order to try to include the scientific evidence into the negotiations, and always we are working on into the subsidiary bodies. Like, and indeed, right, Macarena Sarras is member of the Ministry of Foreign Affairs working into the subsidiary bodies, because Chile is always trying to promote how we can include the science behind. If you don't know, maybe you don't know, but Chile, we have an climate change law that is a very good framework, because that's an climate change law is including and defining what is the governance and what kind of entities we have in Chile. In that moment, and we have a Minister of Environment, a Minister of Science. Here is and in the Minister of Science we have a secretariat. He is the leader, and Carlos Muñoz is there, and he's the leading Carlos Morales. Sorry, I am very confused with Spanish, Portuñol, Portuguese, and French, and so on. So I'm gonna apologize. Carlos Morales, he's the leader of the secretariat, and he's the leader in the Minister of Science and Technology, because we have a scientific committee, is a non-state actor, independent. It's so crazy because my affiliation is according of the Minister of Science, but I'm not member of the state. So it's, we have a specific nomination, and that process is a very democratic process, because the secretariat always is asking for different kind of universities and the scientific community and propose different kind of names. And the secretariat is trying to keep the balance between gender, for example, and disciplines, and regionally, because always we are all concentrated into the capital. Right now we have 11 members, like Camila Fernandez there. She's coming from the south of the Chile. She's oceanographer. I am engineering. And we have another kind of colleagues working in health issues and so on. That's committee. The role of that committee is provide the scientific evidence in order to design and build the NDC. Indeed, the NDC 3.0 was built with the scientific committee, but not just for the scientific committee, because our role was try to engage different universities, researchers, and making workshops throughout the country in order to get what kind of information we need to get locally. Because from my IPCC hat, always we are fighting because we are losing a lot of information locally. We have a lot of information in English. We have a lot of information from the global north, but we don't have, we have a huge gap of the local information in the global south, because we have too many papers maybe published in Spanish or another kind of language. And so that's the role of the scientific committee, is how we can engage and how we can boost and how we can get information from the country in order to try to put that's information for the decision makers in order to build the next NDC, the next long-term strategy, climate strategy, and also That is the level, sorry. And this is at the national level. How you can see, you have the state, you have the ministries. The role of the scientific committee is assess the adaptation plan. And for the Minister of Environment, we have a non-state actors providing the advising in order to get information locally, working with scientific community, in order to get all information what we need in order to support our policies based on science, finally. And the role of us is one is build the long-term climate strategy. Second one is build the National Determinate Contribution, NDC. And right now we are doing the assessment about the sectoral mitigation and adaptation plans. So I would like to finish that. This is a very good strategy in order how we can, because, in Conference of Parties, always we are talking about what do we want? But the good question is how we can move ahead, how we can do the operations. I think the scientific committee is a very good strategy because finally we need more scientific information in order to adjust the goals locally, because finally we need to try to enrich the goals or the climate goals for mitigation or for adaptation plans with the local evidence. Here's you have we are right now writing on a 4 report, and the idea of this is the report development model for the scientific and advisory committee of climate change. One is the definition of priority of the topics. Right now, we are working on the nexus and on oceans, biodiversity and climate. The second one is climate and health. The third one is circular economy. And the 4 reports is about the nexus, water, energy, and food security nexus, because it's a huge issue for Chile. We have fishing, we have agricultural activities, we have another kind of things. And we need to do the scoping and bring the outline. After that, we have an appointment of the authors. And Carlos is bringing the open call for different universities and trying to recruit more on the scientific community in order to write the papers and so on. We are looking forward to include the territorial perspective, because right now we are getting information from the north for the south, enriching that kind of reporting. And we are doing the drafting and scientific cycle. And finally, we need to bring to the government the final output. In the Conference of Parties of Chile in Madrid in 25, and we did one report about the renewable energy. Right now is the most cited reference in Chile and the IPCC, because it was a very good report about how we can deploy renewable energy, how we can reduce the cost of the solar energy. Right now, we are paying $22 per megawatt. It's nothing if you compare with the rest of the country, and we are not subsidizing the renewable energy. It's a free market. Now that's crazy. And finally, I got to say that it's not just scientific community, because on the Secretariat, we are working in different workshops, including students at the schools. We're taking advantage that visits of the different regions. Here's my president, Sandra Cortez, and working in climate and health. And the idea of is work with the schools. We call to different schools to work with us in order to understand what the students are understanding about the climate change. And finally, we are working right now with the journalists and people working into the science communication. Because one of the main findings of us is we have a very good information about science, but we are not communicating the climate change properly. So this is a new challenge. How that scientific committee is working on, and in order to improve the scientific communications. And right now we are giving advice for the Chilean delegates here in COP, for the COP for the plastics, and Camila is bringing advice for the BBGN for the next COP. So always we are providing advising, and this is a very good model in order to try to deploy a proper scientific committee to bring support for the decision makers. Thank you so much, and apologize for my English. I am speaking in Spanish, Portuñol, Francés, and so on. So thank you so much, and to share with you that time. Thank you.
Thank you very much for this illustration. And last but not least, so we will go through the third block on how could we look ahead, actually, and continue to talk about this idea of collaboration. Thank you very much.
Thank you so much, and thank you for the opportunity to be here and to contribute in this very important conversation to underpin and also strengthen between us the role of scientific evidence and experts and consensus in supporting climate litigation, how we set and the norm setting and the evolution of global climate governance, which I think is a very big question, and how we need to develop that quite profoundly. As my other colleagues here have said, I mean, the development of our societies have for a very long time been fundamentally underpinned by legal norms. And it's essential that to understand, as you were saying, that these are actually based on very fundamental norms. And now, I mean, they need to in turn be science-based and based on the best knowledge that we have. And it's a fantastic ruling that we recently have that underpins that. We're living in a time with very profound instability, I think. And we have seen that international order that has underpinned peace and cooperation for decades, it is under pressure. And we've seen international agreements being challenged, in some cases weakened or even violated. And in this context, I think we can all agree in this panel that the need for robust and science-based legal frameworks and strong international collaboration is probably more urgent than ever. And it's inspiring, of course, to see the recent developments in climate law. It's been very powerfully reaffirmed, as Julian was going through, specifically in July this year by the landmark advisory opinion of the International Court of Justice, really underpinning now the obligations of states in respect of climate change, and looking at or really saying very clearly that the more science, the more responsibility. So that is going to grow and grow, of course, and that also underpins very clearly the role of science. I want to just also say that we have some quite recent Norwegian examples that are quite interesting when it comes to this, specifically NGOs bringing forward litigation on specific situations of violations, for example, related to environmental damage, but also specifically indigenous rights in Norway, where actually the ruling was, you know, they ruled the state guilty of violating human rights of indigenous people, which is, you know, quite powerful. And although there is no real, maybe law enforcement, that has had profound consequences, and will continue to have that. So as I said, or as you said, Julian, where now the importance of the, you know, the understanding of the best available science, that marks those are the corner flags for the responsibility, and that's a very powerful statement. And it puts a lot of responsibility then on the states. And also and their responsibility to acquire and to analyze such information, which really makes it, it's a very clear responsibility to embed it in the processes. And it also affirms that states are required to cooperate to promote studies and undertake research programs and encourage the exchange of information and data to establish the appropriate scientific criteria for regulation. So it's not only taking the science that's actually there, but it's actually the responsibility to promote and push that best science even further. So that's very important. I think looking at Europe, it's quite inspiring also to look at how it's been embedded, for example, through the European Green Deal and the European climate law, where it's a by law obligation for the European Union to become climate neutral by 2050, in line, of course, with the advice of the IPCC, and setting intermediate targets of reducing emissions by 55 by 2030 compared to 1990 levels. And I mean, even without the law enforcement part of it, it has clearly, the fact that it's set by law, it's clearly strengthened that agenda. I think that is very clear. And just last week, the EU agreed on a 90% emission reduction target by 2040, and that European climate law has a specific article on scientific advice on climate change, and it establishes the European Scientific Advisory Board on climate change with an explicit note that its mission should not overlap with that of the IPC, and it invites each member state to establish a national climate advisory body. So that's already being put into action. Now, looking at globally at the research organizations, including Science Europe, where I'm currently the president, and the Global Research Council, where I'm also one of the vice presidents, we are strongly committed to supporting decision-making with the best available science. So I'll mention just a few examples on how we do that. Obviously, through financing and conducting excellent collaborative and interdisciplinary research accessible through open science. And I think open science is absolutely key here, because we cannot work with something that is hidden behind paywalls. That is going to be impossible. And when we work with the international collaboration, it's extremely important that we do that with reciprocity and that we do that with equitable partnerships, that we acknowledge that knowledge has to be relevant locally, and that has to happen globally. So we need the science that is relevant for the local communities all over the world. Of course, we have to support academic freedom, also under pressure globally at this point. This is essential for science to be able to inform policy and legal processes. And yeah, so that also relates very strongly to the trust in science. And without trust in science, you cannot have it as a legal basis. That's just fundamental. So that's extremely important. And also providing platforms for dialogue between researchers and policymakers and civil society, and ensuring that scientific outcomes are communicated with integrity and also with transparency. This is also fundamental to make the best science available for litigation. And also, I think citizen participation is extremely important in this sense. We're also working with advancing rapid and living evidence synthesis so that lawmakers and stakeholders have timely access to the latest scientific knowledge, because saying that you have to base your actions on the best available science is very easy to say, but how are the states going to do that in practice? I mean, in this process that we're here to support, that is very much embedded, but the states don't necessarily have that. From the Research Council of Norway and also throughout the EU system, of course, we also have the EU taxonomy now of do no harm when it comes to the research projects themselves. And I also just want to link it to education, where we have to promote education and also trust in science. I think that is that's the cornerstone of having science that can be trusted into legal processes, of course. But it's also a very fundamental part of acceptance, that people accept climate actions. For all of these things, collaboration is key, and effective climate governance will require strong partnerships between states and the civil society and international institutions. So I think you're probably looking to wrap it up now, but just looking ahead, evolving international jurisprudence, such as the recent International Court of Justice advisory opinion, it will, I think, I'm very hopeful, and I do believe that this will continue to shape global climate governance in a strong and effective way. And as legal norms adapt to new scientific evidence and societal needs, it's our collective responsibilities to ensure that science remains at the heart of climate law and policy, and also, as you said very clearly, to secure the implementation and to make law enforcement through collaboration with also with the civil society. So I'm convinced that only by working together across disciplines, across sectors and borders, we can build a climate governance system that is ambitious, just, and effective. And I think science must be our guide and collaboration has to be the method. Thank you.
So thank you very much. As a closing remark, it's true that we decided this year to inaugurate the pavilion with a talk on trust in science and climate diplomacy. And I'm seeing that this has been at the heart of every single panel that we have been carried out here. So I think that we still have a lot about this conversation that needs to be strengthened. I'm going to finish with taking back some words that you mentioned. You were mentioning that it was more than a duty for law, but it took a lot of human wisdom in order to be carried out. So thank you very much for your knowledge of law, but also for your human wisdom. We will finish this panel. Unfortunately, we won't have time for questions and answers, but I imagine that you will stay around, and maybe if someone has a specific question, I'm sure that you'll be happy to answer them. Thank you so much for taking the time, for being on this panel, and for providing all of these incredible examples and keynotes that I am sure have resonates among the people that have listened to them. Thank you very much.